Okay, welcome back everyone. I hope you had a good break and had a chance to meet Spot. Of course, Spot is going to be with us throughout the day, so we'll have much more time to interact with him and the team at MFE. And now, on to panel 2. And this one is very close to my heart. We'll be talking about AI for the future of legal practice. And I'm very proud that I have one of our very own here from Osgood, my dear colleague, Jonathan Penny, who's going to be chairing it. And John, I'm going to have to say a few things about you too, okay? You're good? All right. So John started here at Osgood in July 2020. And he's also a visiting scholar at Harvard's Institute for Rebooting Social Media, a faculty associate at Harvard's Berkman Klein Center for Internet and Society, and a longtime research fellow at the Citizen Lab based at the University of Toronto's Munk School of Global Affairs and Public Policy. Now, he's a native of Halifax, and we're happy that you're here with us in Ontario. He has studied law at Columbia Law School as a Fulbright Scholar and at Oxford University as a Mackenzie King Scholar, one of the very best, I do agree there. He holds a doctorate in information, communication, and the social sciences from the famous Oxford Internet Institute at the University of Oxford, and he was at Balliol College in 2016. And love Balliol. Before joining Osgood, he taught law at Schulich School of Law at Dalhousie University and spent time as a senior research fellow at the Technology and Social Change Project at the Harvard Kennedy School's Shorenstein Center on Media, Politics, and Public Policy, and as a research affiliate of Princeton's Center for Information Technology Policy. John's research and teaching expertise lies at the intersection of law, technology, and human rights, with strong interdisciplinary and empirical dimensions. From established technologies like the internet and social media to emerging ones like AI and machine learning, he aims to understand the legal, ethical, and human rights implications of technology and its role in public and private sectors. And, he spans a host of different disciplines. He's also widely recognized across different media, and there's many here, and I won't list them all. Also, his research on privacy and chilling effects was chronicled by Harvard Magazine, and he won the Reidenberg Kerr Paper Award in 2020. And the list goes on here, and he's also serves on various boards, so he has that governance expertise, and I really can't think of anyone more able to lead the charge on this panel, and we're delighted that you're here with us, John, so welcome.
Well, thank you so much, Pina. That goes, you've gone far too over, and I feel that the panelists that I'll be now briefly introducing, if I were to give the same introduction to each of them, we would have no time to talk about AI and the future of legal practice, which is the fantastic and really important and timely topic that we'll be speaking to in this panel. It is great to be here, and I want to thank Pina for putting this together, and Ashley and all organizers. I think it's such an important and critical discussion to be having at a really exciting time for AI and society and the legal profession. My very distinguished panelists here will be speaking to a range of, I think, really exciting and cutting-edge research and work across a number of different sectors affecting the legal profession, AI, and society. I'll start by just a brief introduction. To my left, I have Professor Sari Graben, who's an associate professor and associate dean, research and graduate studies at Lincoln Alexander School of Law at Toronto Metropolitan University, who really does interesting and I think cutting-edge work at the intersection of law, technology, and public policy. I'm really looking forward to her insights today, and all of you should as well. We also have just past her, Nye Thomas, who's the Executive Director of the Law Commission of Ontario. The Law Commission has been also doing such important work right now on a range of different questions concerning AI, society, questions of regulation, questions of law, questions of ethics, what the legal profession should do, what we should do as a society, and good governance when it comes to some of these important emerging technologies. And so we'll be hearing from him as well. Welcome, Nai. A little bit further down, we have, of course, she goes without saying, Pina D'Agostino, who has organized this fantastic conference and has done so much important work on IP and technology and law, and now is really leading the way here at Osgood on a range of different AI and society projects, not just research. She's a leader in teaching. She's a leader on bringing important actors together like we're seeing today, and so we'll be hearing from her as well. Thank you, Pina. And lastly, we have Ryan Wong, an associate at Smart and Bigger, who is really doing interesting work in the legal profession and his legal practice, and we'll be hearing from him on some really important, again, cutting-edge ideas and ways of thinking about AI in the legal practice. So without further ado, I'd like to welcome the panel. And I'll start off with a kickoff question to each of you. And we'll try to keep the first sort of question around 10 minutes. If you see, I may give a signal or two. And the question that I'll pose to all of you is, in your own professions in law, what has been your experience with AI and the power it has to shape the future of legal practice? Sorry, go ahead.
So, thank you for inviting me to join this wonderful, distinguished panel. I think I'll just start with saying how I came to this work, because I didn't originally start out in this field. I came out a little bit in STS studies, science and technology, in relation to other research areas, mostly around Indigenous peoples and risk. But I joined Lincoln Alexander to form the law school several years ago, and in doing so, we had a very, very in-depth discussion, starting back in 2017-18, as to what would a law and technology curriculum look like. And part of that was definitely AI, as well as other technologies. And that discussion was quickly put into coursework, right? Because everybody in the academy knows, in some ways, you just have to get it done. You have to roll out the type of curriculum that you think you're going to need, and you're going to work with that. And so we rolled out a mandatory curriculum for our students, and based on the curriculum that other faculties were putting in across the world to address the issue. And the impact of AI on that has been so impactful because it's really hard to teach in law school. We bit off something so important, so needed, but so difficult to deliver that we are in a constant process of creativity. And I think that other schools are too, because I've gone out in this work that I've been doing to help, lead and to strengthen up our curriculum. What are other schools doing? How are they actually delivering this curriculum as well? And so what we've found is that most schools are putting some specialized curriculum in place or some broad curriculum in place, but no matter what, are having a difficulty delivering that at the JD level. And why that is, I can go into some details on what is needed what I think is needed in the future of legal pedagogy for this area, but the challenges come from the debates we're having as to whether technology is something that is new to law, or it's just another challenge that law can overcome. And AI is the penultimate example of that, because it fundamentally changes, I argue, actually how we think about law. It is not something that we just apply law in service to, right? So that is one component of AI and legal education. We are the lawyers who will help the creators of AI to overcome the difficulties, but actually law itself and how we use AI in law, and I would say in corporate decision-making, in arbitration, in all the ways that we actually do decision-making, administrative decision-making. The list goes on. Anywhere where there is decision-making and AI is being implemented, we are at a moment where we haven't really identified exactly how law is changed by that. And, sorry, do I have 10 minutes altogether to myself? Or?
Yes, you do.
Awesome. Okay, so, so when we say that AI is doing decision-making, is it mimicking law? And the answer is no. AI is not mimicking law, and it is not mimicking humans. It is actually implementing a myth that we in law schools and as lawyers generally like to perpetuate or buy into or believe, which is that law is a series of rules that can be implemented in a logical and foreseeable way. But really, law is a series of exceptions, and we don't know that exception occurs until it's over, right? Until we look backwards, which was the conversation at the panel prior to ours. So if we are really always engaging in the human decision-making, the human exceptions, and the myriad of factors that we know from behavioral psychologists, that when we make decisions, it is not just based on some rational basis that we've listed, although that is how we rationalize it, but our decision-making is actually impacted by many subtle and maybe unknowable factors that go into that process. If we know that, and we know that's actually relevant in decision-making, then we know that what AI is doing is it's crystallizing a series of rules that aren't necessarily applicable when done by a live actor, let's say. So for us, AI is actually changing how do we structure the legal systems in which others operate. Secondly, I would say that AI really impacts the personalization of law, which also is a factor. That when we depersonalize law and we automate it, we actually contribute to a more isolated way of engaging with each other. And in doing that, by isolating ourselves, we've again undermined something so important in legal decision-making or legal hearings, which I think the Law Commission report really identified, but as, oh, there's something more than a hearing isn't just a place where we state our reasons back and forth. It's a place where we feel heard. And I don't know, I'm sure that wasn't eloquent enough, but it's capturing the essence of human trust. And we are putting our trust in decision makers who've been entrusted by others, and now we are altering that. We are depersonalizing trust, so it is not about the individual in front of us. Of course, we know it's about the system in front of us, right? We have identified that the data is reliable. But even if we identify that the data is reliable, even if we know that it's not necessarily just about the biased data, which is a problem, of course, that we keep addressing, but it's not just, we've identified crystallized data, crystallized decision-making. And so when we depersonalize that, I think, and I love this field because you get to just look into the future and think about these things, I think we're asking whether we're changing the way that we contest that. Because an individual can no longer contest the system in an AI system. You must mobilize, you must organize, you must have a large data set of those who have been wronged with you. And so what we're doing is we're actually setting up a different legal system of contestation that is not individualized anymore. We have to bring collective action, you have to use data in that collective action, and you're got to get people angry in a way. And I wonder whether AI in the legal profession, we haven't really thought about how decision-making is changing the very legal systems in which we're operating. Okay, how much time do I have?
Two, 3.
Awesome. So I'll just briefly introduce what I think are the major challenges in legal pedagogy around this. We all have heard, or anyone can read, just Google, how do we teach law and technology, and there are a plethora of blogs and comments and papers and futurism. But I think that they don't do justice to how disconnected that work is from how we have practiced legal academies so far. So when we recruit faculty members who are able to engage with this, yes, they should, we need a wide swath. We need people like, I actually can't speak to the technical capabilities of anyone at the table, but those who are maybe not as technically capable to get into the technologies with which we're working. But also you need those people who are technically capable, we know this, those who are the computer scientists, those are the coders. But we don't just need them because they understand. Those aren't insiders. An insider is actually someone who is trying to unpack the future of that technology. And investing in those faculty members that will lead the projects is key, because the projects have such long time spans. To really get into the difficulties of the technology, you have a time span of maybe 10 years. You can't do a project in a couple of short years and understand it. You can critique it from the outside, you can get to know a lot of people, you can work with others, but really working in that design realm is immensely time-consuming and not necessarily valued in the academy. So I speak to many, many designers who are sprinkled all over the place in legal academy, and they're doing work that's not necessarily understood by their peers because it doesn't look like traditional legal work or legal academic work. And that needs a lot more support, because when our students come in, their time spans are even shorter. They have 3 years to get in and figure out what law is, year one, right? We all know this. We've all gone through it if we're in law school, gone through law school, teach law school. That is about a year, and then you're really into getting a few specialized topics. If you want to get involved with a project and get skilled, even if you have the computer science background, even if you have the capability, you have to be stepping into something that's ongoing. You can't start from scratch within law school. And so the training of the generation to come who can engage with this is critical, and yet we haven't really thought about what are the supports to put in place. That's it. And in time.
That's perfect. Thank you very much, Professor Graben. Some really, I think, important insights there. Something about the importance of technical and technological skills, both for those in the academy, but also the importance of these for students going forward. Something we're thinking about at Osgood with our current curriculum reform processes. Nai, same question to you. What has been your experience with AI and the power it has to shape the future of the legal profession?
First, I'll tell you a little bit about my organization. We're the Law Commission of Ontario. We're actually located upstairs. We're an independent legal policy think tank. And in the last couple of years, we've been doing a lot of work around AI regulation, AI and human rights, AI and privacy, AI and due process, and how you think about AI governance, keeping in mind some of these fundamental legal principles. And a lot of our work is organized around that. First, I'll tell you about how AI is currently being used in the justice system, because it's actually being used more than people may appreciate. The cutting edge of a lot of AI in the public sector and in justice is in the criminal justice system. Predictive policing systems, algorithms and AI systems that make recommendations on bail or sentencing, biometric facial recognition systems that are used for surveillance. AI is being used to determine government benefits, access to government services. AI is being used in all kinds of different regulatory contexts, most notably in the Securities and Exchange Commission in the United States, but also it's beginning to be used elsewhere. AI is used obviously in all different forms of screening applications, whether it be employment stuff, education stuff, a whole different series of things. So it's not all in Canada, but it's coming. And if we're talking about bracing for impact, this is the impact. These are the implications we may be thinking about. There are a lot of disparate applications. Employment screening is obviously not the same as bail. It's not the same as determining government benefits. The through line legally, however, through a lot of these systems are, a lot of them affect human rights, a lot of them affect privacy, a lot of them affect due process issues, so how you challenge decisions. So a lot of work that my organization and others are doing are thinking about how you protect, promote these transcendent legal principles across these different applications, irrespective of whether they're the public sector, private sector, criminal justice, civil justice, employment law, immigration, you name it. And that's the work that we're doing. We talk about access to justice and AI. First thing you need to know about is access to justice in Canada. And as you may know, there is in fact an access to justice crisis in Canada. It's expensive, it's slow. There's unequal access to services, unequal access to decision-making. A lot of decision-making is subjective. It's opaque. It's often racialized. There are extraordinarily poor metrics of justice system decision-making. We don't know a lot about how the system actually works because it's so decentralized. Data systems are so poor, it's even hard to track the travels of a single client through the justice system. So there's a lot wrong with justice in Canada. There's an access to justice crisis. And of course, my field is justice, but it could be talking about the healthcare system, could be talking about a lot of other areas where the same kinds of issues apply. If you lay AI on top of the justice system, you can see the potential. It's extraordinary. Faster decision-making, cheaper decision-making, greater access to decision-makers. In a perfect world, fairer decisions, decisions where bias is not a feature of decision-making, but rather bias is identified and decisions are fair across different communities and stuff. Even things like AI language technology, simple translation technology potentially has an extraordinary impact in the justice system because it's so difficult for people to communicate in languages that may not be English or French in the justice system. So the potential is there to really improve the system. There's a quote from an American academic that kind of captures the potential that I really, really like. It's from a guy, professor, I think he's at University of Pennsylvania, Kerry Coglianese. He says, AI has the potential to crack the code of mass adjudication. And for an access to justice advocate like myself and John and others, it's really exciting. There's really, really potential, great deal of potential. The problem, of course, is that a lot of the issues with AI have been revealed in the justice system as well. Racialized decision-making, mass surveillance, problems with the black box and opaque decision-making, problems with your ability to challenge decisions, problems with explanations. A lot of the issues we know are features of some AI systems are exacerbated when it comes to justice because that's where you're contesting individual rights and the like. So the question is, how do you balance this stuff? How do you maximize the benefits of AI while minimizing the potential harms? Can I just do a time check? Just see. Okay. So the current prevailing thinking, and I'll say at the outset, I'm actually very optimistic about this. And there tends to be a pessimism and cynicism about AI in a lot of the justice system because of the law of the worst case scenarios, because a lot of the demonstrable harms of the early implementations of AI and algorithmic technology in a whole host of contexts, most notably in criminal justice, but that's not the only area. And that pessimism has infused a lot of the analysis of AI systems. My own view is actually quite optimistic. And it's because there is an extraordinary amount of work being done by my organization, many others, public sector, private sector, NGOs, civil society organizations, around the concept of trustworthy AI. So what are the rules or practices or laws or procedures you use to ensure that AI systems, you can leverage the benefits of AI while minimizing the harms. And it's not complete yet. It's an ongoing process. But if we just think about this in terms of how much work is being done and the proactive work that is being done to identify these good practices, I'm actually quite optimistic. And I will cut it off there. So, thank you.
Okay, great. Thanks so much, Nai. Some really important thoughts on access to justice, and we'll come back to them. I think I'd like to follow up on a few of those issues, but let's continue with Pina on the initial question. Same to you in your experience. How can AI, or what is your experience of AI and its power to shape the future of the legal profession?
Well, with Nai, I'm also optimistic, and as an educator and teacher and researcher within the university, I've really witnessed welcome change within the university, and I think the university is getting it right in figuring out that we can't solve the complex questions on our own, not only within the Osgood realm or within the Faculty of Science, Engineering, Business. We need all of us to come together. And I really welcome that interdisciplinary approach. And I feel very at home here at York University, because York, as you know, for a long time, we've said, we're that interdisciplinary university. Well, I think on the AI front, we really are that. I was part of a task force. I was the co-chair with Professor Elder, who you'll meet later today. But essentially, over the last 3 years, we did a lot of empirical work talking to faculty across the university, and we realized that there's a wealth of talent and incredible work being done within the pockets of the university, but we're not talking to each other. So we chronicled all of that in our report, which we launched just last year, Fostering the Future of Artificial Intelligence. And in that, one of the recommendations was really to galvanize this strength and bring us all together to figure out these complex challenges. So I'm really happy that we've come to that moment, and later today we'll be hearing from VPRI, Dr. Mira Sifa on this. But I think, and sorry, and I goes to your points, like these are complex questions, and you need the technical expertise with the legal, with the scientists all coming together. And I really feel that the university needs to have a strong voice in leading these debates, because the university, unlike many other hubs, and not to slight anyone, but the university really, our business is that of education. Everything really starts and continues with education. And when we think about fostering the future of legal practice, like this is something that I really take to heart here at the law school. And I think we've also figured out that it has to be, human-centered. And we keep seeing a lot of these centers now pop up like mushrooms everywhere, right? I was just at Stanford Law School, and they just started within the university, HI, right? Human-centered AI. So every university that wants to count, that wants to be at the table, is getting it and is doing something. So I think we also need to be talking to one another, and I'm so glad that Ryerson, TMU is here at the table, and I welcome that collaboration, and I think the government welcomes that collaboration. Also in my own work, so thinking back to research that, for many times I thought I was like the, speaking ahead of my time, and I'm looking at Professor Wever. So back at the University of Oxford, Professor Wever was the PI leading us, and I was, at the time just doing my doctoral work. But one of the projects was really working as a lawyer with computer scientists and social scientists on data governance. So this was 2001. And I remember speaking to many a conference room, and literally I'd see eyes glossing over, rolling over, and I just felt like burrowing myself into a hole, because it was just people didn't have the appetite to hear from me, right, or know about the issues. And so when we are, and even now in many ways, we're somewhat refractory to talk about data and the systems that are being deployed in terms of even the ownership question. Who should own, access, and control the data? We often talk about, of course, privacy is important, cyber is important, human rights, but these are all slices. We need more interdisciplinarity even within the law to deal with these issues. So that's something that we tackled firsthand back in 2001, and we looked at the health ecosystem and the electronic health record at the time. And we talked about those who are disenfranchised, and of course, Dr. Roberts talked about this, those who are sidelined by technology. And guess what? They're the patients, right? The patients themselves. Who's talking to them? We did that, and we conducted many workshops. So I feel like I think it's time now to also resurrect a lot of that work and bring it more, into the fore, especially now with all these groups mushrooming. So I welcome that. And I've always been intrigued by how technology, and in this case we're talking about AI, but any technology, and how it interrogates the existing social structures and the existing legal regimes, and how the law needs to play catch-up. Is there a way for the law to anticipate this? How can we train our students to do better? So thinking of this, something that you may have seen also is AIDA, as I like to call it, the Artificial Intelligence and Data Act. And there, I think, is a case in point where it's a welcome introduction from the federal government. But again, you see that we're looking primarily to privacy, right? We're not looking at the ownership question that I just noted. So what do we need to do? Do we need to do some surgery on other legal regimes, come up with sui generis legislation? What are the tools that we have in place to make things better? Now, this event is a case in point. So there's been a proliferation of AI events. I think there's like another few going on today, but you're at the right one. And I really believe that when we first started Bracing for Impact, this was February of 2018, we were leading the charge here at the university. And so our goal is to plan to continue to do that, but of course, with more and more partners together. Now, I love, you're talking about curriculum, development and legal pedagogy. That's something that keeps me up at night. It really does, because I really dream and want that perfect class, that perfect program where that student can shine. And I'm looking to Ryan right beside me, right? And so, I've really tried to revolutionize or innovate the curriculum in some way. And I think one of the initiatives that I'd like to mention, and it's a nice segue going to Ryan, is the Innovation Clinic. So this is a clinic that I started back in 2010, and really in partnership with leading law firms, because yes, it is about access to justice and fairness, and there isn't a lot of that in the law, as we know. And especially when we look to commercializing intellectual property, when you have that student that comes to you and they have that bright idea, what do? How do we help them out? So I rolled up my sleeves, and with the law firms, we decided we're going to start this clinic where we help students, we help faculty across the university to start up and think about how to protect, leverage their ideas to innovate our Canadian ecosystem, right? So that started in 2010, and I crunched the numbers, and it's pretty amazing. So these are just, we need to have some metrics too, right? So we actually undercut almost $2 million that would have otherwise been billable. So we had our law firms devote so many countless hours working together with our students, who are the leaders really helping, these clients. And that amounts to about 6,000 billable hours. So I'm really proud of this project. And so I mentioned 2010. And so this is where AI kicks in. In comes Isaac Newton, right? Or Putin, as we put it, IP, right? And so we figured that over the time, we learned a few things. So 10 years of running a clinic, guess what? You get a lot of repeat questions. So answering the same questions over and over again, we thought, why don't we harness all of this data that we're getting, right, with the power of AI to build a chatbot, to automate in many ways this process and to make accurate information more accessible. Because I don't know how many of you, when you come across IP issues in the news, oh gosh, it drives me crazy. There's a conflation constantly between what is a copyright, what is a patent, what is a trademark. And if I have to be repeating that all the time, right, it gets a bit mundane. So it starts with those bedrock questions to build a chatbot that anticipates them and encourages people to come, the public. It's free, and they can access this resource, and we keep on building it. And here, two of the communities, again, we talk about, those disenfranchised and those sidelined by the system. Really, when we look at women, female entrepreneurs, female inventors, and they often are, not at the table, or they don't have access. Many of them are not, the patent filers. And I'm looking to Constantinos Yorgaras at the Canadian Intellectual Property Office. And of course, his team has done incredible work uncovering this data. So women were more sensitive to looking at, that data, and as well the indigenous communities. And so Paul Saparis, when you were chatting this morning on your project and how you help in Inspire, that's something that, we need more and more of these collaborations to work together to build accurate data that is accessible and can help. And so I think that's a good segue to Ryan, because Ryan has been working with me on the chatbot since its inception. So I'll pass it over to you to chat a bit more about it.
Thank you, Professor. Before I get into the demo, we would need the, okay. But before I get into the demo, I want to speak briefly about the three-step process we take to develop the chatbot. The first step is creating the question bank. And so these questions come from a variety of sources, and as Professor D'Agostino has mentioned earlier, a lot of these questions come from our innovation clinic clients, and we really want to target those questions and build those questions in first. We also have sources on the internet that we use, like the CIPO and WIPO databases, and these come in the form of FAQs. So we also build the questions in there as well to help us broaden our set of questions and also to reach a wider audience. Once we have our question bank, we build these questions in the chatbot as intents. By intents, we mean concepts or ideas that are underlying the question itself. And so we're really focusing on the information of what the user is intending to get from that question. We train the chatbot to 5 to 10 alternative questions to let them learn what the intent is really about. And so let's say, for example, if we have a question like, what is a trademark? An alternative question will be, can you explain what a trademark is? The last step is testing. This is the area where students help out a lot. We ask a group of students to do two things. The first thing is to test the intents themselves and make sure that the intents are working properly. The second part is testing the questions in different ways and trying to ask the same question in a variety of different ways, in as many ways as possible, and see if the intent is still going to be able to answer that question. So now we're going to go on to the demo itself. But I want you to imagine an inventor that has an idea that they would like to patent and commercialize for market entry. They have some IP knowledge, but not enough to really know exactly what they need to do. And so they find the IP Oz Good website and they go into the chatbot. And one of the first questions they usually ask is, how do I get, sorry. Oh. Nope. It's always, okay, so the first question would be, what is a patent? So here the chatbot gives us an answer, a definition of a patent. Second question would be, why should I get a patent? Inventors are really trying to figure out the commercial aspects of a patent. And so one of the questions they would also inevitably ask is, what should I consider before getting a patent? Really doing amazing work there. A cost is always important, so how much does a patent cost? And finally, how do I file for a patent? So, as you can see here, most of our answers actually include a link, and one of our goals for the chatbot is to direct our users to more credible sources and reliable sources on the internet. So most of these links are actually going to CIPO and WIPO pages. And so that's something that we want to continue on doing and include more links to our answers. and hopefully also include more answers to government pages as well. The great thing about a chatbot is that it will continue to grow. We're always looking for grants and funding to help us support us in that manner, and to also maintain the chatbot as well as support the students to do this work for us. And so really the more data we put in, the more chatbot will learn and develop and be able to answer more and more questions as we go. So that's everything.
Thanks so much, Brian. That is fantastic. I think the only way we can take this to the next level is if we get Spot in here asking questions of the chatbot. That would be sort of like the only next level that you could take it. But that is absolutely fascinating, and you can see already some of the really important. When I said cutting edge initiatives that Pina has been leading, I think this is a fantastic example of that. So we've had a number of, I think, really important and interesting threads here from each of the different panelists, and I'd like to pull a few of them. So we'll move to Q&A now. There are both microphones here. If you have a question, please stand up, and we'll field questions from the crowd. I have a few questions, and we'll also be keeping an eye on the live feed for questions from there as well. But and probably the only other rule of moderation and Q&A is that, again, just to reference, if Spot wanders in here and wants to take the mic, we'll have to defer to Spot as well. But let me come back to an issue that I flagged earlier that Nai talked about, and I think it'd be important for us to follow up a little bit on it, and that's access to justice. So I'd love to hear from the panelists a little bit more on this count. About how AI can either enable or undermine access to justice. Go ahead, sorry.
You want to start with Nai first?
Oh, sorry. Go ahead, Nai, and maybe since you have talked about some of the promises and peril on this count, if any specific ideas about what the legal profession in particular can do to ensure that potential and success rather than some of the risks and peril that you mentioned.
Sure. I mean, I talked about being optimistic, talked about the potential. That's contingent. You know, the potential, the benefits of AI ain't going to happen by themselves. It's going to take work to get there, and it's going to take, in my view, regulation to get there. You know, notwithstanding all the positive, proactive efforts that are going on around the country, around the world, in kind of the trustworthy AI space, of which there is a lot. Ultimately, if you're concerned about human rights, if you're concerned about privacy, if you're concerned about due process, if you're concerned about the ability of people to challenge decisions that may affect them, you're talking about a form of legal regulation at a certain point. I am not a fan of ethical AI, which is a term of very common term. It's a little bit of a cheap shot. I'm in favor of legal AI, and it's an important distinction policy on the policy space and in the legal space. There have to be certain legal parameters governing AI systems. Not all of them are the same. I do not believe that every AI system has to be subject to the full panoply, the full Cadillac model of legal regulations. That's because not every AI system has the same impact. There are some systems, however, which can be identified that have greater impact on vulnerable communities, on legal rights, constitutional rights, human rights, privacy issues, surveillance issues. Those can be identified, and those should be subject to higher standards. It's possible to do that. In fact, there's a lot of work in my organization and others working on all different kinds of tools for identifying such things. I'll just make a pitch for us. The Law Commission is working with the Ontario Human Rights Commission and the Canada Human Rights Commission, working on an AI human rights impact assessment. First in Canada, I think, at least I'm going to say so. That helps, whether it be governments, it's work in progress that helps either governments or helps organizations think about the potential impact on human rights of their systems. Not every system is going to be the same. Traffic management system's a lot different than a bail system, and they should be treated differently. But that's what it takes, in my view. It's not the only thing it takes, but it's a necessary condition for achieving trustworthy AI and leveraging some of these benefits while minimizing some of the harms.
Great, thanks so much, Nai. Anyone else want to jump in on that question? If not, I can move on. All right, let's do it. So it was great to hear some optimism on this count for the potential for AI and society and the legal profession in particular in teaching. And I'm optimistic. I think law students are really well placed because we teach students to be comfortable with uncertainty, and I think the most interesting and toughest and most difficult questions today are interdisciplinary, as you mentioned, Pina. But to get to that optimism, to see that sort of bright future, there are challenges in this context. And so I'd love to hear panelists Pina or Ryan speak to this. What are some challenges for teaching legal skills in this field, given AI's, the inherent nature of AI and the limits it might place on transparency? Sorry, do you want to jump in on that too?
Yeah, so I think that the difficulty of teaching it is finding what are you teaching, right? So are you going to use, when you're offering law school curriculum, there's a lot of different corporate providers, I would say, but also legal providers that want you to engage with their technology. For all the good reasons that we always have, really, incorporated what would be called legal practice or legal technology into our teaching in some limited fashion, quick law being one of them, right? The easy one. That did change the way we practiced. That incorporation requires quite a bit of investment, I would say, in thinking through why are we working with this, to train students to use it for legal practice. So I like to think, an AI, access to justice, and I just want to link these two. Law school curriculum definitely wants to look at access to justice. Access to justice and AI on family law is, in some ways, in my mind, a no-brainer, right? It's the most expensive engagement with law that most people have some engagement with, right? 50% of the population divorces, 50% of the population needs it. So if we think about how we would develop or incorporate that into our training, we are engaging with either quick acceptance, not able to really critique it or understand it, and who is well positioned to do so. Is every student to be trained on this AI technology and then engage with it, or do we select a few students who are very capable and well prepared, or is this just our grad students? I think we have some key questions around what are we doing with this AI technology in the curriculum. For positive. I'm not totally negative. I just want to know, even for positive purposes.
Yeah, go ahead,
Yeah,
Pina.
no, just to add, I think we could train and educate our students to learn almost anything. I think the issue lies with who is doing the teaching, right, and how it's being done. So, and there's nothing special now, and we're rolling out AI curriculum, but it's the same in any other area of the law that has to tackle the new questions. An example, stem cells, right? I can't imagine someone writing an article on stem cells and the law without actually talking to a stem cell scientist or teaching about it. So I'm actually married to a stem cell scientist, and I was horrified at reading much of the literature that was springing up, at the beginning of, when it was sexy to write about it. I, who live with one, I'm scared to do it. So I think we can, we need to work more collaboratively with the experts in those different fields. So whether it's stem cells, whether it's AI, so there you bring in the coders, the computer scientists, and work collectively together to put the curriculum together, and also have, we do this a lot in the law school, like guest lectures, but things where we don't just feel that, we're know-it-alls in our own little domains. And I think that's, talking about ethics. We're taught this in the rules of professional conduct. Even when in our practice, if we don't know an area, it is incumbent on us to find the expert and bring them in to properly advise our clients, right? And I'm glad at least see our students are nodding. But I think that's also that ethical obligation we need to discharge even in our teaching and in our curriculum development.
Absolutely. Ryan, did you want to?
Yeah, I think I can come from a more of a student perspective here. I think AI as a subject area is really diverse and really broad. And so for a student, I think it's kind of daunting to get into AI law as an area. And so having conferences like these where students can come in and participate and be a part of it, I think is a big step forward.
Great. And I see we have a question from the audience.
Yeah, thank you. I'd like to build on this. Thank you, everyone. So I'd imagine that if you had a room full of students in other disciplines in the social sciences across this university and in the technical sciences, they would have similar conversations. Like, this stuff is interdisciplinary. How do we get into a room with people talking about the same topics, but in the different languages and subject-specific, terms of art that are necessary for this? So my question, I guess, is how do we, and what is the role, I guess, of the university in supporting the kind of interdisciplinarity that we need that bridges, because right now it falls on the individual academics who are mentoring the individual students to build their networks, to bridge those networks, and so that labor gets intense.
Yeah.
And it burns the people out. I've seen, my work is in health and AI. To try to do that work is impossible on top of your regular workload. So what are the kinds of ways that we can see the institutions supporting these and helping us create these interdisciplinary opportunities for our students? Do you have spitballing?
That's a great question.
That is a great question. Well, I have some ideas. So the university has already started trying to bring us together, more on the research front, right, with the circs that we've had, and I'm part of a team, and really fostering that interdisciplinarity within the university. We haven't done that yet, though, on curriculum development, and I think that's where you're getting at, Ian, right? And so to do that, we need resources and we need time. Because as you know, many of my colleagues, I see some here in the room, will know that our time is more and more fractured, and more is being asked of us, with the current challenges we face. So I think if the university can help us on that regard and maybe have a grant for, curriculum development, or we call it micro-credentials, whatever we want to do, to get us together and figuring out how we innovate in our curriculum.
Absolutely. And by the way, I should say that that's just not any questioner from the crowd. That's Professor Ian Stedman from the School of Public Policy and Administration at York U. So thank you, Ian, for the great question. Did anyone else want to jump in on Ian's? Okay. So how about, we've got maybe 2 minutes left. Any final questions from the crowd? Okay, great. Go ahead, please.
Well, first off, thanks, guys, everybody. It was really entertaining listening to what you had to say. As a university student, I kind of have a perspective in my undergraduate degree of learning about AI, but not the implications that it might have on society. And I've only remembered one time in my whole degree so far that we've talked about, for example, a sampling bias of looking at cases and the racial injustice that prompts. So I'm just curious, as a student, what can we do to generate more exposure to stuff like that, because we don't look at it.
Sari's got an answer to that.
Yeah. I don't have an answer in the sense that you're going to be satisfied.
No problem.
I think that there is a big problem in law, which is our data sets are not as easily accessible and recognizable for analysis in Canada relative to the US. So even when we look to train students, we're using US case law because it has been scrubbed and placed into usable data sets, and in Canada we have a lot more complexity on the ownership, the use, and the innovation in relation to those data sets. So I think that and this was one of the topics of the panel, but it's really about taking that head on. We really have to advocate much more strictly to government and within our own academies about how we're going to use that data set of law.
Okay, I think that's a great note to finish on. So if we could just a round of applause to thank our panelists for a lovely discussion.